ओके सो वेरी वार्म गुड मॉर्निंग टू ऑल ऑफ यू। आई होप मैं आप सभी को ऑडिबल एंड विजिबल हूँ। इफ यू पीपल कैन हियर माय वॉइस एंड इफ यू पीपल कैन सी मी ऑन द स्क्रीन, प्लीज कमेंट सेक्शन में यस सर, ऑल गुड कुछ भी लिख के कंफर्म कीजिए, एक थम्स अप दीजिए ताकि मैं ये कंफर्म कर पाऊँ कि मैं आपके सामने ऑडिबल एंड विजिबल हूँ। ठीक है, तो चलिए आज के डिस्कशन को हम लोग शुरू करते हैं। तो अगर अभी तक हम आप लोगों ने हमारे चैनल को सब्सक्राइब नहीं किया है तो प्लीज जाके हमारे चैनल को सब्सक्राइब कर दीजिए एंड डोंट फॉरगेट टू प्रेस द बेल आइकन एंड डोंट फॉरगेट टू लाइक दिस वीडियो। और अगर अभी तक आपने हमारे एमपी सिविल जज प्रीलिम्स के क्रैश कोर्स को चेक नहीं किया है तो डू चेक इट आउट, लिंक इज इन द डिस्क्रिप्शन बॉक्स, जिसमें आपको 10 से ज्यादा मॉक्स, रिकॉर्डेड वीडियो लेक्चर्स, वन ऑन वन मेंटरिंग एंड डाउट क्लियरिंग सेशंस मिलते हैं। एंड वी आर ग्लैड टू अनाउंस दैट दिस पर्टिकुलर बैच जो एमपी सिविल जज प्रीलिम्स का क्रैश बैच है, इसमें आपको कई सारे लाइव डिस्कशन भी मिलते हैं वन ऑन वन मेंटरिंग में। तो चलिए, अब जैसा मैं आप लोगों को बता देता हूं, हम लोग 2019 फेज वन शिफ्ट वन का क्वेश्चन पेपर डिस्कस कर रहे हैं, जिसमें हम लोग आज पर्टिकुलरली स्पेसिफिक रिलीफ एक्ट, लिमिटेशन एक्ट, एमपी लैंड अकोमोडेशन, एमपी अकोमोडेशन कंट्रोल एक्ट, देन एमपी एलआरसी और इंडियन एविडेंस एक्ट के कुछ क्वेश्चंस को डिस्कस करने वाले हैं। सो हियर इज द फर्स्ट क्वेश्चन फॉर द डे। In a suit for injunction under Section 40 of Specific Relief Act 1963, damages, option A, cannot be awarded, B, can be awarded in addition to injunction, C, can be awarded in lieu of the injunction, and D, can be awarded either in addition to or in substitution for injunction. So what should be the correct answer? Question number 41. जी हाँ, बताइए क्वेश्चन नंबर 41 का क्या होगा करेक्ट आंसर? दे आर स्पेसिफिकली स्टेटिंग कि सेक्शन 40 ऑफ स्पेसिफिक रिलीफ एक्ट 1963 के अंदर डैमेजेस कैन नॉट बी अवॉर्डेड, कैन बी अवॉर्डेड इन एडिशन टू इंजंक्शन, कैन बी अवॉर्डेड इन ल्यू ऑफ इंजंक्शन, एंड डी इज सेइंग कैन बी अवॉर्डेड आइदर इन एडिशन टू और इन सब्स्टिट्यूशन फॉर इंजंक्शन। सो व्हाट शुड बी द करेक्ट आंसर फॉर दिस क्वेश्चन? जल्दी से बताइए। क्वेश्चन नंबर 41, यस, इट्स करेक्ट आंसर इज डी, दैट इज अगर आप सेक्शन 40 ऑफ स्पेसिफिक रिलीफ एक्ट को जाके पढ़ते हैं तो इट इज सिंपली स्टेटिंग दैट इंजंक्शंस कैन बी अवॉर्डेड आइदर इन एडिशन टू और इन सब्स्टिट्यूशन टू डैमेजेस, राइट? नेक्स्ट क्वेश्चन, अंडर स्पेसिफिक रिलीफ एक्ट 1963, power of court to engage experts is provided under which section? This is purely a section based question. क्या बोल रहा है कि पावर ऑफ द कोर्ट टू एंगेज एन एक्सपर्ट इज गिवन अंडर विच सेक्शन? योर ऑप्शंस आर सेक्शन 20A, सेक्शन 14A, सेक्शन 20B एंड सेक्शन 20C. व्हाट शुड बी द करेक्ट आंसर? पावर ऑफ द कोर्ट टू एंगेज एन एक्सपर्ट इज गिवन अंडर विच सेक्शन? 14A, 20A, 20B and 20C. What should be the correct answer for question number 42? Yes, its correct answer is B for Bangalore, that is section 14A, right? As you all are aware that section 20A is talking about infrastructure project, section 20C is talking about speedy disposal of the suit in specific relief act, so section 14A is talking about power of the court to engage an expert. Next question, specific relief act, if a person is dispossessed from immovable property without due process of law, he has to file a suit for possession. Option A, within 3 months, option B, within 4 months, option C, within 12 months, and option D, within 6 months. If a particular person has been dispossessed from his immovable property under section 6 of a specific relief act, that particular person has right to file a suit for the recovery of possession under which of the following time period? Option A, 3 months, option B, 4 months, option C, 12 months, and option D, 6 months. What should be the correct answer? Yes, its correct answer is option D, that is within 6 months, right? Chaliye, next question. Under section 20 of specific relief act, for disposal of a suit, maximum period provided for, options are A, 9 months, B, 18 months, C, 24 months, and D, 36 months. ये जो क्वेश्चन नंबर 44 है ना, बिफोर आई स्टार्ट माय डिस्कशन विद द आंसर ऑफ दिस क्वेश्चन, मैं आपको एक चीज क्लियर कर देता हूं। क्वेश्चन नंबर 43 का हर्षवर्धन जी बोल रहे हैं डी। बिल्कुल हर्षवर्धन जी, गुड मॉर्निंग टू यू, एंड डी इज द करेक्ट आंसर। क्वेश्चन नंबर 44, section 20C of specific relief act provides the specific time for disposal of suit, right? 9 months, 18 months, 24 months and 36 months. So this particular question's correct answer 44 का correct answer will be B, that is 18 months. लेकिन यहाँ पे देखने वाली बात यह है कि अगर आप सेक्शन 20C की लैंग्वेज को जाके एक बार पढ़ेंगे तो it is nowhere given directly 18 months. It is stated that usually a suit in the case of a specific relief act has to be disposed of within 12 months, and the court may further extend the time period for another 6 months. So that is how we got the idea of 18 months. Chaliye. Next, question number 45. That is, plaintiff has filed a suit for only declaration of title, though he is not in the possession of property. The suit is barred under which provision of Specific Relief Act 1963? Plaintiff has filed a suit only for declaration of title, though he is not in the possession of the suit property. The suit is barred under which of the following section of Specific Relief Act 1963? Option A, 34, option B, 35, option C, 36, and option D, 37. What should be the correct answer? Suit for the declaration. When the suit for declaration is barred, this is given under which section? अगर आप लोगों ने स्पेसिफिक रिलीफ एक्ट पढ़ा है तो यू पीपल मस्ट बी अवेयर अबाउट डिक्लेरेशन सूट किस सेक्शन में है. दैट पर्टिकुलर सेक्शन विल बी द करेक्ट आंसर. यस, सो क्वेश्चन नंबर 45, इट्स करेक्ट आंसर इज गोइंग टू बी A for Ahmedabad, that is section 34. Section 34 is stating about declaratory suit. It is also stating the grounds on which a person cannot file for declaratory suit. So its correct answer is A. Next question. Under Specific Relief Act, in which of the following cases the court cannot order ratification of an instrument? Under Specific Relief Act, in which of the following cases? हर्षवर्धन जी बोल रहे हैं 45 का ए. बिल्कुल हर्षवर्धन जी, 45 का ए इज द करेक्ट आंसर. अंडर स्पेसिफिक रिलीफ एक्ट, इन विच ऑफ द फॉलोइंग केसेस द कोर्ट कैन नॉट ऑर्डर रेटिफिकेशन ऑफ एन इंस्ट्रूमेंट? सेक्शन 46. ठीक है, सॉरी, क्वेश्चन नंबर 46, ऑप्शन ए, वेयर द इंस्ट्रूमेंट दो थ्रू fraud does not express the real intention of the parties. Option B, where the instrument through mutual mistake does not express the real intention of party. Option C, where the instrument is article of association of a company. And option D, where the rectification of the instrument can be done without prejudice to the rights acquired by third party in good faith and for value. अगर आप लोगों ने particularly section 26 को पढ़ा है specific relief act के, तो you can get the direct answer of this question. So section 26 is talking about rectification of the instrument. Question number 46 थोड़ा सा बड़ा है, ध्यान से पढ़िएगा, but बहुत easy question है. ठीक है, so it's question number 46. Its correct answer will be C. That is where instrument is articles of association of company. In that case, rectification of instrument cannot take place. Right? चलिए, next question. Question number 47. Any other application for which limitation period is not provided. देखिए, क्वेश्चन नंबर 47 से अब लिमिटेशन एक्ट के क्वेश्चन शुरू हो गए हैं. Any other period for which limitation period has not provided in the limitation act, then the limitation period will be A, 3 years, B, 5 years, C, 12 years, and D, 30 years. Question number 46 का हर्षवर्धन गौतम जी C. बिल्कुल हर्षवर्धन जी, C is the correct answer. Question number 47. Any other application for which limitation period has not provided in the Limitation Act, the limitation period will be 3 years, 5 years, 12 years, and 30 years. What should be the correct answer? Yes, question number 47. लिमिटेशन एक्ट में कहां पे ये पर्टिकुलर चीज आपको देखने को मिलती है कि अगर किसी भी पर्टिकुलर चीज के लिए कोई भी लिमिटेशन पीरियड नहीं है, इट्स लिमिटेशन पीरियड विल बी ऑप्शन ए, दैट इज 3 years.
राइट, याद रखिएगा ये चीज। चलिए नेक्स्ट क्वेश्चन नंबर 48, सेक्शन 5 ऑफ लिमिटेशन एक्ट डज नॉट अप्लाई टू, सेक्शन 5 ऑफ लिमिटेशन एक्ट डज नॉट अप्लाई टू ए सूट, बी अपील, सी एप्लीकेशन, डी ऑल ऑफ दी। Section 5 of Limitation Act does not apply to A suit, B appeal, C application and D all of these। ये देखिए, ये जो क्वेश्चन नंबर 48 है बहुत रिपीटेटिव क्वेश्चन है, लगभग लगभग मोस्ट ऑफ द जुडिशियल एग्जाम्स में पूछा जाता है और अधिकतर स्टूडेंट इसे गलत करके आते हैं। तो बताइए क्वेश्चन नंबर 48 का व्हाट शुड बी द करेक्ट आंसर, जल्दी से। यस, इट्स करेक्ट आंसर इज ए, दैट इज सूट। याद रखिए, Section 5 of Limitation Act does not apply to a suit or an application that is made under Order 21 of CPC, that is for the execution of decree, and in the cases of HMA, an application made under HMA, ठीक है, हिंदू मैरिज एक्ट या हिंदू अडॉप्शन एक्ट 48 का डी नहीं। यहां पे क्वेश्चन को ध्यान से देखिएगा आप, you will be able to understand what they are simply trying to convey। हर्षवर्धन जी, अपील और एप्लीकेशन पे लगता है सेक्शन 5, ओनली द एप्लीकेशन फॉर एग्जीक्यूशन ऑफ डिक्री वहां पे नहीं लगता है, बट इन अपील एंड एप्लीकेशन यूजुअली सेक्शन 5 इज हैविंग इट्स एप्लीकेशन। तो इट्स करेक्ट आंसर विल बी 48 का ए, दैट इज सूट। नेक्स्ट, इन कंप्यूटिंग द पीरियड ऑफ लिमिटेशन फॉर एनी सूट, अपील और एप्लीकेशन, that day shall be excluded on which? Option A, limitation period is to be computed. Option B, judgment has been pronounced in appeal. Option C, time requisite for obtaining a copy of judgment, and D, all of the above, right? So 49, what should be the correct answer? अगर आप लोगों ने सेक्शन 12 पढ़ा है लिमिटेशन एक्ट का, तो वहां से ये डायरेक्ट क्वेश्चन है, सेक्शन 12 की लैंग्वेज से ये क्वेश्चन इंस्पायर्ड है, राइट? इन कंप्यूटिंग द पीरियड ऑफ लिमिटेशन फॉर एनी suit, appeal or application, that day shall be excluded on which limitation period has to be computed. Option A. Option B, judgment has been pronounced in appeal. Option C, the time requisite for obtaining a copy of judgment, and D, all of the above. So what should be the correct answer? Question number 49, its correct answer is D for Delhi, that is all of the above, right? Section 12 बोलता है that the time required for obtaining the copy of judgment, like judgment has pronounced in appeal, limitation period, ठीक है, the limitation period has to be computed, so जिस particular day से compute होना है, that particular day shall be reckoned or excluded। Question number 50, yes Harshvardhan ji, 49 का D is the correct answer। Question number 50, Limitation Act, for the purpose of this act in a suit of pauper, ठीक है, काजल दुबे जी, yes D is the correct answer काजल जी। Question number 50, for the purpose of this act in a suit of pauper, the suit shall be deemed to be instituted on the date dash 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 question mark। Option A, when the application for leave to sue as a pauper is made। Option B, when the application for leave to sue as a pauper is allowed। Option C, when the suit is registered, and option D, it is the court to decide the date of institution। Question number 50, what should be the correct answer? They are talking about pauper suit या suit by the indigent person, right? So question number 50, its correct answer will be yes। क्या होगा question number 50 का? Its correct answer is A for Ahmedabad, that is when the application for leave to sue as a pauper is made, it will be deemed that the suit has been instituted for the limitation period। Yes Harshvardhan Gautam ji, 50 ka A is the correct answer। चलिए, now we are moving on question number 51, that is talking about MP Accommodation Control Act। ठीक है, आप में से अधिकतर लोग Accommodation Control Act MPLRC पढ़ चुके हैं या पढ़ रहे हैं। So I think yes काजल दुबे जी, 50 का A is the correct answer। So I think you will be in the position to attempt MP local laws question under section 13 subclause 2 of MP Accommodation Control Act. The fixing of provisional rent is necessary where a dispute relates to A, area of rent only, B, amount of rent, C, area of rent and amount of rent both. D, neither area of rent nor amount of rent. So what should be the correct answer for this question? Yes, under section 13 subclause 2 under MP Accommodation Control Act, fixing the provisional rent is necessary where the dispute is relating to A, area of rent, B, amount of rent, C, area of rent and amount of rent both, D, neither area of rent nor amount of rent. So its correct answer will be C, C for Calcutta. That is, when a particular suit is relating to area of rent or amount of rent, in both of the cases, the fixation of rent is necessary to decide the dispute. Yes. Next question. Question number 52. MP Accommodation Control Act. In case of a composite tenancy of a residential and non-residential purpose. 51 ka Harshvardhan Gautam ji, its answer will be C, not B. That is, when a suit relating to area of rent or amount of rent, in both of the cases it is required, right? Yes, Kajal Dubey ji, its answer will not be B, its answer is C. Sorry, its answer is B. I'm really sorry. My bad, its answer is B, that is amount of rent, right? Area of rent ke liye it is not necessary. My bad. I'm extremely apologetic for the same, right? I got slight confused. Question number 52. MP Accommodation Control Act. हर्षवर्धन काजल दी दोनों ही लोग आप लोग सही हैं, ठीक है? Now, in case of a composite tenancy of a residential and non-residential purpose, the landlord can seek eviction of tenant. A, by providing need for residential purpose. B, by providing need for non-residential purpose. C, by providing need for any purpose. And D, by filing a suit under the special provision as contained in section 20 of the Act. When a particular property has been given on tenancy that includes both residential and non-residential purpose, the landlord can seek eviction of tenant on which of the following ground? For residential purpose, for non-residential purpose, for both residential and non-residential purpose, and D, by filing a suit under special provision as contained in section 20 of the Act. So its correct answer will be yes. 52, its correct answer will be C, by proving need for any purpose, that is either residential or non-residential purpose. ठीक है? Next question क्या बोल रहा है? 53. MP Accommodation Control Act. If a tenant fails to deposit or pay the amount as required under section 13 of Accommodation Control Act. 52 का हर्षवर्धन जी बोल रहे हैं D. नहीं हर्षवर्धन जी, if you are proving the need for any of the purpose, that will be sufficient, right? MP Accommodation Control Act के अंदर if you are proving the need either for residential or non-residential purpose, easily the property can be claimed, right? Question number 53. MP Accommodation Control Act. If a tenant fails to deposit or pay any amount as required under section 13 of Accommodation Control Act, A, court shall order to the cost. Option B, court shall pass a decree against the tenant. Option C, court shall initiate punishment proceeding against the defendant. And option D, court may order the defense against eviction to be struck out. Yes. So question number 53. What should be the correct answer? Option A, court shall order to cost. Option B, court shall pass a decree against tenant. Option C, court shall initiate punishment proceeding against defendant. And option D, court may order the defense against the eviction to be struck out. So its correct answer is D for Delhi. Question number 53. Its correct answer is D for Delhi. Next question. MP Accommodation Control Act. The tenant has, whether before or after the commencement of this act, caused or permitted to be caused substantial. Harshvardhan Gautam ji, yes, 53 ka D is the correct answer. 54. The tenant has, whether before or after the commencement of MP Accommodation Control Act, caused or permitted to be caused substantial damage to the accommodation. This is the ground of eviction as mentioned in, देखिए डायरेक्ट क्वेश्चन है ये बेयर एक्ट से, सेक्शन 12(1) I, section 12(1)(k), section 12(1)(m), section 12(1)(n. What should be the correct answer? Causing substantial damage to the property is a ground of eviction under 12(1)(i), 12(1)(k), 12(1)(m), 12(1)(n. What should be the correct answer? So 54, its correct answer is B for Bangalore, that is section 12(1)(k. Yeah, right? Chaliye. Now last question for MP Accommodation Control Act, that is, where is wrong about appeal against the order of rent controlling authority, right? So the question is, sorry, not where, what is wrong about appeal against the order of rent controlling authority? Yes, Harshvardhan Gautam ji, 54 ka B is the right answer. Option A, it can be filed in the court of district judge. B, the decision of appellate court shall be final. Option C, the appeal shall lie from every order of rent controlling authority made under this act. Option D, limitation of filing appeal is 90 days, excluding the period requisite for obtaining the copy of order. So which of the following is wrong? हमें गलत statement ढूंढना है, right? Remember, here we have to find the incorrect statement. So its incorrect statement for question number 55 will be D for Delhi. That is, limitation of filing appeal is 90 days, excluding the period requisite for obtaining the copy of order, right? Question number 55, its correct answer will be D. Next question. 56. Question number 56 is related to section 29 of MP Land Revenue Code. Under section 29 of MP Land Revenue Code, who is competent to transfer a revenue case from one district to another? Under section 29 of MP Land Revenue Code, who is competent to transfer a revenue case from one district to another? Option A, state government. Option B, revenue board. Option C, chief secretary. And option D, revenue minister. Question number 56, what should be the correct answer? Under section 29 of MP LRC, who is competent to transfer a revenue case from one district to another district? State government, revenue board, chief secretary, and revenue minister. Yes, 56 ka B is the right answer. Bilkul Harshvardhan ji, that is revenue board. Question number 57, reinstatement of Bhumiswami dispossessed can be made. An order for reinstatement of Bhumiswami improperly dispossessed can be made under which section of MP LRC, MP Land Revenue Code? Option A, section 248. Option B, section 250. Option C, section 250 clause B, and option D, section 253. ठीक है? Reinstatement of Bhumiswami improperly dispossessed can be made under which section of MP LRC? Your options are question number 57 के 248, 250, 250B and 253. 57, its correct answer is option D, that is Bangalore, section 250. Section 250. 58 का नहीं अंकिता जी, it's C नहीं होगा, its answer will be B, section 250. Right? चलिए, next question. 57, you are saying 58 तो अभी अंकिता जी मैंने पूछा ही नहीं है. 57 का yes, B is the correct answer. Next question, 58. Boundaries of all villages shall be fixed and demarked by permanent boundary marks, comma, is provided under. MP LRC का question है, boundaries of all the villages shall be fixed and demarked by permanent boundary marks is provided under which section of MP LRC? Under section 121, under section 124, under section 125, under section 126. What should be the correct answer? Question number 58. Boundaries of all the villages shall be marked under section 121, 124, 125, 126. Question number 58. What should be the correct answer? Yes. Question number 58. Its correct answer is B for Bangalore. That is under section 124. Section 124 is talking about boundaries of all the villages shall be fixed and demarked by permanent boundary marks. Right? 58 ka yes, B is the correct answer. Harshvardhan Gautam ji. Next. Question number 59. MP Land Revenue Code. Failure. Yes, Ankita Gupta ji, 58 ka B is the correct answer. Failure to vacate land in favor of allotee of land would be an offense punishable with the imprisonment of maximum period of A 6 months, B 1 year, C 3 months, and D 3 years. Yes. Failure to vacate land in favor of allotee of land would be an offense punishable for a maximum imprisonment of, question number 59 में, option A 6 months, option B 1 year, option C 3 months, and option D 3 years. What should be the correct answer? Question number 59. Yes, its correct answer is, question number 59 ka correct answer is D for Delhi, that is 3 years, right? Chaliye. Next question, question number 60. That is last question from MP LRC. Yes, 59 ka Harshvardhan Gautam ji, D is the correct answer. Who will decide the dispute relating to demarcation and maintenance of boundary lines? Who is going to decide the dispute relating to demarcation and maintenance of boundary line? Ankita ji, 59 ka B nahi hoga, 59 ka correct answer will be D, that is 3 years. ठीक है? MPLRC question number 60. Who will decide the dispute relating to demarcation and maintenance of boundary lines? Your options are Tahsildar, option B Sub-Divisional Officer ya SDO, option C Collector, and option D Commissioner. Tahsildar, SDO, Collector, Commissioner. Question number 60. What should be the correct answer? Question number 60. Its correct answer is C, that is Collector. याद रखिएगा हर्षवर्धन गौतम जी, क्वेश्चन नंबर 60 करेक्ट आंसर इज सी, दैट इज कलेक्टर. ठीक है, नॉट तहसीलदार. दे आर टॉकिंग अबाउट डिस्प्यूट रिलेटिंग टू डिमार्केशन एंड मेंटेनेंस ऑफ बाउंड्री, सो इट्स करेक्ट आंसर इज कलेक्टर. नेक्स्ट सेक्शन, क्वेश्चन नंबर 61, इंडियन एविडेंस एक्ट. ठीक है, फैक्ट्स which though not in issue are so connected with fact in issue as to forming part of the same transaction, whether they incurred at the same time or at the same place or at different times and different places are relevant. Question number 61. It is directly related with section 6 of Indian Evidence Act, which is talking about res gestae, forming part of the same transaction. Option A are irrelevant, option B are relevant, option C are partly relevant, and D none of the above. Yeah, none of these. What should be the correct answer? Facts which though, sir, can you please explain question number 60? Question number 60, like you want me to explain. Just give me a minute. I'll just share my complete screen and we'll try to share it in a much illustrative way, right? (61) Ankita ji, yes, B is the correct answer. Let's do one thing, Harshvardhan ji. Once I'll complete this particular discussion with this class, then I'm going to discuss this particular question, right? Question number 60. Is it okay? 61 ka B is the correct answer. Yes. 62. Indian Evidence Act के अंदर FIR is not substantive evidence. It can be used during trial. A, to corroborate the information. Option B, to contradict the information. Option C, to corroborate and contradict the information, both. And D, neither to corroborate nor to contradict the information. Question number 62. FIR is not substantive evidence. It can be used during trial. A, to corroborate the information. B, to contradict the information. C, to corroborate and contradict the information, both. D, neither to corroborate nor to contradict the information. Question number 62. What should be the correct answer? FIR can be used for which purpose? Question number 62. What should be the correct answer? Yes, its correct answer is C, Calcutta. Question number 62. Its correct answer is C, Calcutta. That is, the information like FIR can be used to corroborate and contradict the information. Question number 63. क्वेश्चन नंबर 63 थोड़ा सा लेंथी देखने में लग सकता है, लेकिन बहुत इजी है, तो ध्यान से देखिए. क्वेश्चन नंबर 63, इट इज रिलेटिंग टू योर सेक्शन 45. यस हर्षवर्धन जी, 62 का करेक्ट आंसर विल बी सी. 63, द ओपिनियन ऑफ अ एक्सपर्ट may be obtained under section 45. Yes, Ankita Gupta ji, 42 ka C is the correct answer. The opinion of the expert may be obtained under section 45 of Indian Evidence Act in relation to A, science, art, law, finger impression, handwriting and signature. Science including medical matters, art, law, finger impression and handwriting. C, science including medical matters, art, law, finger impression and handwriting and signature. D, science, art, foreign law, finger impression and handwriting / signature. What should be the correct answer for question number 63? 63 का correct answer is D. बिल्कुल हर्षवर्धन जी, क्योंकि बाकी जो सारे ऑप्शन हैं, they are talking about law. यहां पे भी आप देखिए बी ऑप्शन में भी लॉ है, सी ऑप्शन में भी लॉ है. So expert cannot give his opinion on the matter of law, but he can give his opinion on the matter of foreign law. So its correct answer will be D. Yes, 63 ka correct answer is D. Next question. When the language used in a document is on its face ambiguous or defective, dash of facts which would show its meaning or supply its defect. A, evidence may be given. B, oral evidence may be given. C, documentary evidence may be given. And D, evidence may not be given. Question number 64. Yes, Harshvardhan ji, foreign law ke relating the opinion of the expert matters. Okay? Expert can give his opinion. Question number 64. Yes, when a document is having patent ambiguity, that is on the face it's defective or ambiguous. Okay? So evidence may be given, oral evidence may be given, documentary evidence may be given and evidence may not be given. Question number 64. अगर आप लोगों ने सेक्शन 93, 94 आराम से पढ़ा है इंडियन एविडेंस एक्ट का, यू विल बी एबल टू आंसर दिस क्वेश्चन, कोई प्रॉब्लम नहीं होगी इसमें. Question number 64. Its correct answer is D for Delhi. That is, evidence may not be given. Where there is a patent ambiguity, in that cases, evidence may not be given. Next question. Exception to hearsay rules. 64. 64 में oral evidence may be given. हर्षवर्धन गौतम जी नहीं, oral evidence cannot be given. देखिए एक चीज समझिए, नहीं अंकिता गुप्ता जी 64 का B नहीं होगा. आप लोग लॉजिकली ये चीज समझिए. इफ सपोज देयर इज अ डॉक्यूमेंट, देयर इज अ एग्रीमेंट व्हिच इज स्टेटिंग दैट आई वांट टू सेल माय हाउस टू बी एट द कॉस्ट ऑफ रुपीज 5,000 और 10,000, तो यहाँ पे पेटेंट एम्बिग्विटी है. इस केसेस में नो एविडेंस कैन बी गिवन. ठीक है, क्लियर है. चलिए नाउ क्वेश्चन नंबर 65. एक्सेप्शन टू हियरसे रूल्स आर प्रोवाइडेड अंडर ए Section 17 and 18, option B 32 and 33, option C 34 and 35, and option D 36 and 37. Exception to hearsay rule. Usually hearsay evidences does not having any kind of admissibility, but there is an exception to this rule, and this particular exception is contained under which section? 65 question number का option A बोल रहा है 17 and 18, B 32 and 33, C 34 and 35 and D 36 and 37. Its correct answer is 65 का B, that is 32 and 33, right? चलिए question number 66, that is which section of Indian Evidence Act provides that evidence shall be weighed not counted? Evidence shall be weighed not counted. Yes, Ankita Gupta ji, B is the right answer. Question number 66. Which section of Indian Evidence Act provides that evidence shall be weighed not counted? Yes. Option A, section 132, option B, section 134, option C, section 130, and option D, section 131. Yes. Evidence shall be weighed not counted. This particular provision is contained under which section? 132, 134, 130, 131. What should be the correct answer? Question number 66. Its correct answer is B for Bangalore. That is section 134. Section 134 what it states, यहाँ पे क्वेश्चन को थोड़ा सा घुमाया गया है. सेक्शन 134 की लैंग्वेज क्या बोलती है? नो पर्टिकुलर नंबर ऑफ विटनेसेस आर रिक्वायर्ड to prove a particular fact. So what they are trying to convey by that particular statement under section 134 ki even a single witness is sufficient to make 66 नहीं 132 नहीं होगा, its answer will be 134. अंकिता जी क्वेश्चन की डिटेलिंग को समझिए. Question is simply asking for what is the need of the question. No particular witness will be required. That means the evidence shall not be counted, rather than it shall be weighed. ठीक है. अगर कोई आई विटनेस है वो सेक्शन 134 के अंदर अकेला विटनेस है, that will be sufficient. ठीक है. In case of a murder to penalize a person, so evidence shall be weighed, not counted. That is stated under section 134. Right? So 66 ka correct answer will be B, that is section 134. Question number 67. By which section of Indian Evidence Act 1872 the judge is empowered in order to obtain proper proof of relevant facts in any form, at any time, of any witness or of parties about any fact relevant or irrelevant? Yes. So which particular section of Indian Evidence Act is empowering the judge to order to discover or to obtain proof of relevant fact from any time, at any witness or any party? ठीक है, whether relevant or irrelevant. ये लास्ट के प्रोविजन से है इंडियन एविडेंस एक्ट के. ये क्वेश्चन नंबर 67. ऑप्शन ए 166, ऑप्शन बी 167, option C 164 and option D 165. What should be the correct answer? Power of the judge कहां पे दिया हुआ है इंडियन एविडेंस एक्ट में? Yes, it is given under section 165. So its correct answer is D for Delhi. Next question, question number 68. The question is whether A committed a crime at Mumbai on a certain day. अंकिता गुप्ता जी 167 नहीं है. अंकिता जी 167 is stating that if any order has been made by the court by not following up, by not considering a particular evidence, then also the decision of the court will not be reversed until and unless it is not causing the failure of justice. That is stated under 167. So its correct answer will be Ankita ji 165. Question number 68. The question is whether A committed a crime at Mumbai on a certain day. The fact on that day A was at Chennai is relevant under which provision of Indian Evidence Act? Option A section 9, option B section 10, option C section 11 and option D section 12. Question number 68. Plea of LEB से related है. Facts which are not otherwise relevant becomes relevant under which section? This is what is asked in question number 68. So the question is whether A committed a crime at Mumbai on a certain day. The fact that A was at Chennai is relevant under which section of Indian Evidence Act? Section 9, section 10, section 11, section 12. What should be the correct answer? 68 ka. 68 ka correct answer is C, that is section 11. Very good, Harshvardhan ji. Chaliye, next question, question number 69. In which of the following case, yes, Ankita ji, C is the correct answer. 69. In which of the following case did the Supreme Court holds that compelling a person to give his specimen writing will not amount to testimonial compulsion for the purpose of Article 20 subclause 3 of the Constitution of India? सीधी सीधी से अगर मैं वन लाइनर बात बोलूं तो गिविंग अ स्पेसिमेन का जो प्रोविजन है उसकी कॉन्स्टिट्यूशनल वैलिडिटी चेक हुई थी किस केस में? सो योर ऑप्शंस आर ए स्टेट ऑफ बॉम्बे वर्सेस काठीकालू. मतलब ये आपसे पूछ रहे हैं कि जो सेक्शन 67 है और जो आपका पर्टिकुलर सेक्शन 73 है, इन दोनों सेक्शंस की लीगल वैलिडिटी किस केस में सुप्रीम कोर्ट ऑफ इंडिया ने चेक की थी? ए स्टेट ऑफ बॉम्बे वर्सेस काठीकालू ऑगड़. बी यूसुफ अली वर्सेस स्टेट ऑफ महाराष्ट्र. सी स्टेट ऑफ यूपी वर्सेस राम सेवक. डी रोहित शेखर वर्सेस नारायण दत्त तिवारी. What should be the correct answer? 69. 69 का correct answer is yes, Harshvardhan ji. Its correct answer is A, that is state of Bombay versus Kathikalu. क्वेश्चन नंबर 70, क्वेश्चन नंबर 70 क्या बोल रहा है? अ नॉन कन्फेशनल स्टेटमेंट recorded under section 164 of CrPC. A non-confessional statement recorded under section 164 of CrPC. Option A is a substantive piece of evidence. B is not a substantive piece of evidence. C may or may not be a substantive piece of evidence. And D, all of the above or all of these. Question number 70. A non-confessional statement recorded by a magistrate is a substantive piece of evidence, not a substantive piece of evidence, may or may not be a substantive piece of evidence. यहाँ पे देखिए वो कन्फेशनल स्टेटमेंट नहीं बोल रहे हैं 164 के अंदर, नॉन कन्फेशनल स्टेटमेंट की बात हो रही है, याद रखिएगा. सो क्वेश्चन नंबर 70, व्हाट शुड बी द करेक्ट आंसर फॉर दिस क्वेश्चन? क्वेश्चन नंबर 70, व्हाट शुड बी द करेक्ट आंसर फॉर दिस क्वेश्चन? जल्दी से बताइए. यस, अंकिता गुप्ता जी, इट्स करेक्ट आंसर इज नहीं, इट्स करेक्ट आंसर इज बी, दैट इज इट इज नॉट अ सब्सटेंटिव पीस ऑफ एविडेंस. A non-confessional statement recorded under section 164 is not a substantive piece of evidence, right? But a confessional statement recorded under 164 is a substantive piece of evidence. 70 का हर्षवर्धन जी बोल रहे हैं सी. नहीं, यहां पे एक चीज समझिए आप लोग. Statement given to a magistrate during custody, if it is a non-confessional statement, it cannot be considered as a substantive piece of evidence and it cannot be the sole basis of conviction. यहां पे आप समझिए, अगर मैं बात करूं कोरोबोरेटिव और सब्सटेंटिव एविडेंस की, तो इनमें डिफरेंस ही यही है कि केवल कोरोबोरेटिव एविडेंस के बिना पे किसी को सजा नहीं हो सकती, लेकिन केवल सब्सटेंटिव पीस ऑफ एविडेंस के बिना पे किसी को सजा हो सकती है. अगर सेक्शन 164 के अंदर एक पर्टिकुलर पर्सन ने कोई भी नॉन कन्फेशनल स्टेटमेंट दिया है और अगर आप उसे सब्सटेंटिव पीस ऑफ एविडेंस की तरह कंसीडर कर लेंगे, इट सिंपली मींस दैट द पर्सन कैन बी हेल्ड लाइबल. समझिए, एंड दैट इज द नॉन कन्फेशनल स्टेटमेंट. So it is not a substantive piece of evidence. So its correct answer will be B for Bangalore, that it is not a substantive piece of evidence. हाँ, अगर यहाँ पे नॉन कन्फेशनल की जगह पे होता a confessional statement recorded under section 164 of CrPC, then we can say that yes, its answer will be A, that is it is a substantive piece of evidence. So I think that is it for the day. As of now we have covered today we have discussed about SRA, that is Specific Relief Act, Limitation Act, MP local laws. Then we have discussed about Indian Evidence Act. Tomorrow we are going to move further with Indian Evidence Act के remaining of the question. Then we are going to discuss about IPC and CRPC के some of the question. So get ready for next class. Tomorrow we are going to meet at 9 a.m. Ankita Gupta ji, sir, admission. What you are trying to ask, Ankita ji, please elaborate your question more. ठीक है, अगर यहां तक आप लोगों ने वीडियो देख ली है and if you find it informative, don't forget to like the video and subscribe to channel. ठीक है, and please create engagement in the videos. Please try to put some of the, I should say, comments in the comment section so that we can increase the engagement of the video. Ankita Gupta ji, sir, admission can be considered as substantive piece of evidence. Sir, question 60. Okay. Harshvardhan ji, definitely I am coming on question 60. Just give me a minute. पहले अंकिता जी का क्वेश्चन देख लेते हैं. Sir, admission can be considered as a substantive piece of evidence. Yes, Ankita ji, admission can be considered as a substantive piece of evidence. Right? Clear hai, Ankita ji? Harshvardhan ji, I'm just coming on question number 60. So that is it for the day. Now, if any one of you are having any confusion, just let me know. Except question 60, हर्षवर्धन जी वो हम डिस्कस करने वाले हैं. अगर अभी तक आप लोगों ने एमपी सिविल जज प्रीलिम्स के क्रैश कोर्स के लिए एनरोल नहीं किया तो डू चेक इट आउट, लिंक इज इन द डिस्क्रिप्शन बॉक्स. अब आते हैं वापस एक बार अंकित सॉरी हर्षवर्धन जी के क्वेश्चन पे, क्वेश्चन नंबर 60. जस्ट गिव मी अ मिनट so that I can check that question number 60. Yes, question number 60. dispute relating to demarcation of and maintenance of boundary lines, right? यही क्वेश्चन था, maintenance of boundaries. So I'm just sharing my screen to give you the correct answer for this particular question, right? Just a second. Just a minute. I have to share my complete screen. Ankita Gupta ji, thank you, Ankita ji. You share. हाँ जी. Let's come back to Harshvardhan ji. I hope you can see my screen. There is a case, ठीक है? This particular case is Mrs. Sunita, wife of Rajen Bairagi versus State of MP and others. ठीक है? Now, in this particular case, if you can particularly see the facts, and at the bottom, like if you will follow up the judgment, I'm telling you the name of the case again, that is Mrs. Sunita Bairagi versus State of MP and others. 1st October 2020 का judgment है. In this particular case, it was clearly held, right, that the cases relating to demarcation and maintenance of boundary shall be decided by the collector, right? Harshvardhan ji, on the basis of this, I formed this answer. Before 2018 amendment, Harshvardhan ji is saying it was collector's decision was final. Now, अभी मैं आपको इस particular case में I'm just going into the case का detail and I'll just mark that particular thing where the court held, MP High Court held this particular thing, right? That in these cases, collector can decide, right, Harshvardhan ji? Just give me a second. Now, आई एम नॉट श्योर मैं इसको मार्क कर पा रहा हूं नहीं कर पा रहा हूं. मैं आपको बता दे रहा हूं, अगर आप हर्षवर्धन जी 6th पॉइंट को एक बार जाके पढ़िएगा, इस पर्टिकुलर जजमेंट के, इंडियन कानून पे यह जजमेंट दिया हुआ है. 6th पॉइंट को अगर आप पढ़ पा रहे हैं वेयर आई हैव मार्क्ड इट, तो प्लीज ट्राई टू रीड इट. ठीक है, 6th पॉइंट को एक बार पढ़िए, यू विल गेट द क्लियर आइडिया. अंडर सेक्शन 250 ऑफ MP-LRC is not maintainable before Tahsildar, right? Because the land survey is no more a vacant agricultural land. Tahsildar does not have jurisdiction to direct the handing over of the vacant position by diminishing the construction of houses, right? हर्षवर्धन जी 6th point अगर आप देख पा रहे हैं, I hope it is clear to you. चलिए, now I hope you people enjoyed today's session. ठीक है, I have tried my best to give you whatever I can give, like from my end best. तो मिलते हैं नेक्स्ट क्लास में कुछ और नए डिस्कशंस के साथ. मीनवाइल टेक केयर, स्टे हेल्दी, बाय बाय. मिलते हैं नेक्स्ट क्लास में. एंड डोंट फॉरगेट टू लाइक द वीडियो. अगर यहाँ तक आप लोगों ने वीडियो को देखा है तो don't forget to like it and don't forget to subscribe to our channel and don't forget to press the bell icon. Take care. Bye bye.